Also, ADR is used to describe this consensual alternative, talking about the concept of showing understanding, mutuality, just for us to agree among ourselves. So, more broad definition of ADR may include adjudication, negotiation, mediation, or indeed any other form of contractual dispute resolution technique. Of course, the debate is going on. Instead of looking at alternative, then we should just call it appropriate. So we are not saying we are looking at alternative. What would be the appropriate dispute resolution? This is what is going on in the modern time. To look at this in a broader, different way. Okay. Yeah. So, having said that, also we look at some of those other issues in terms of where are the sources of construction contract disputes, so that as a practitioner, as a professional, you can actually look at the sources and look at how you may, forestall occurrence of disputes on any construction project. So that being understood as a professional, it helps you to ensure that a dispute is avoided even before it occurs. Okay. Research has revealed that contract could be, read differently, subjectively, different parties interpreting it in different way, and this could constitute a main cause of conflicts in construction projects. One of the major problems in construction contract or any conflict disagreement issue is about communication, usually communication between the parties. So it is always important that you manage communication between parties in any construction project. Once there is a gap in communication, misrepresentation, misunderstanding in communication, this could actually lead to disputes, and it could take resources, it could take time, wastage, and the likes before it could be resolved. So it follows that the frequent cause of construction conflict is unsuccessful communication between the parties to any construction contract. Because once you are not understanding yourselves, or you are not agreeing with the interpretation of what you are getting from the contract terms, then there is a problem. That means somebody needs to understand the contract terms and be able to manage the relationship between the parties. It is very, very important that parties to construction contract are able to do that. So disputes are one of the main factors which prevent the successful completion of construction projects. So thus it is important that you understand the causes, where the disputes emanate from, in order to complete any construction project on time, on budget, and at the required quality. So in resolving disputes and looking at some of the sources where disputes could emanate, researchers had carried out different studies, and they've been able to tell us that on construction projects, we have disputes emanating from the owner. That means owner-related disputes. So in this case, it could be variation initiated by the owner, change of scope, late giving of possession. After the sign of the contract, the contractor is to move into site. And of course, the contractor is not given the possession on time. And you believe that the time for the commencement of the project has started. If that is not properly managed, it could lead to problem in form of a dispute. Acceleration of work, when the contractor to finish, on particular time, and maybe in his own thinking too, he thought he could be able to manage and do that. By agreeing to that, that could be a problem, and it could lead to dispute. So unrealistic expectations and payment delays. These are issues that could emanate from the owner, that is the client. So we have client-related dispute. And of course, it means when you manage any construction contract, you need to look out for some of these things that have been highlighted: variation, change of scope, late giving of possession, acceleration of the work, unrealistic expectations, and of course, payment delays. The other one is contractor related. The source of the dispute could actually be from the contractor. And how? Maybe the contractor is delaying work progress. The client is paying on time, but the contractor is not carrying out the work in tandem with the spirit of the client paying on time. Time extensions. The contractor is asking that the delivery date must be extended. Financial failure of the contractor. The contractor is having problem financing the project. Once he collects money, only God knows the way he manages it. So when there is a financial failure, is a challenge, is a problem. That directly is common among indigenous contractors. But today we have some indigenous contractors that are performing better when it comes to financial management, and of course, they are performing. Technical inadequacy of the contractor. If the contractor is not having the required manpower and of course, plant requirement to carry out the work to the required quality, is a challenge. Tendering is another contractor-related problem because there are informations that are stated in the tender form, but the contractor did not look at those ones. The only thing the contractor knows is that he needs to price and submit. Some of the details of the requirement of the contract that had been stated before tendering that he needs to know, he did not look at it. That could be a potential dispute source. The quality of the works. If the contractor is not carrying out the work to the required standard and quality, is also a major challenge, a problem, which must be resolved. So once you see that the quality of work might not be as required, then there is a problem. And that is why in pre-qualification of contractor, you need to be sure that this contractor has the capacity to produce the required quality by the client, so that the satisfaction of the client is assured. Then we have the design-related problem. We have design errors, inadequate or incomplete specifications, quality of design, availability of information. It is just like while we're doing our mechanical and electrical services taking off, if you remember, you observe that many of the information that we need to get from the drawings, we wouldn't be able to get them. So if you don't have adequate information as a quantity surveyor, you may not be able to put adequate specification in your description. And by the time the work is being executed, it could now be an issue between the client and the contractor that, oh, you have to do this, the kind of sanitary appliances that I wanted you to do. This is what I have expected. And man is saying, no, according to the description here, there is nothing like I should put a concealed system. And man, no, but the designer should have understood that in this modern time, how will you be putting the system on the WC? I wouldn't want to see my system outside. That kind of a problem is something that, as an experienced professional, you should have forestalled it even before the commencement of construction. And that means adequate specification as required for the needs of the client should have been included in what the consultant put in his description. Design errors, where you are supposed to have 1.2, wide window. And of course, in that space, the maximum speed you can have there is 750. And somebody in the door window schedule, you have 1200. These are issues that needs to be resolved. And the man is now saying that, oh, instead of pricing for 1.2 or installing a 1.2, what I have to install is 750. And of course, that could be the need for them to now make an agreement that, oh, this is not what it's supposed to be, but this is what we agreed to be. If care is not taken, if it is not properly managed, it could end up in a dispute. The same thing when you have a building, the architectural drawing and the structural drawing is not aligning. Both do not agree. It's a problem, which means there will now be need for you to ensure, like I used to tell you, when you take off, you need to ensure that your architectural drawing and the structural drawing agrees. Once there is agreement between the two, is a potential source of dispute. And that is why you always raise your RFI, request for information, once you observe discrepancy in drawing. So the quality of the design and availability of information are very key to avoiding dispute on construction projects. Also, another source of dispute that have been established is the contract related. And what are those ones? You have ambiguities in contract documents, different interpretation of the contract provisions, risk allocation, other contractual problems, which means it is not impossible that the documents that are required, there are ambiguities in them, some things that are not too clear. So you now have issue understanding what should be done and what should not be done. Because the way you understand a particular term is different from the way the client understands it. And perhaps instead of you to now agree with the consultant, you want to stick to your own understanding, because the consultant would have been the one to tell you this is the understanding here. However, sometimes even the consultant too may not have adequate, experience or knowledge to solve some of the ambiguities in contract documents. And that is why whenever there is discrepancies in contract documents, flag it, let it be known by the parties involved in the contract, and that should be resolved. Otherwise, if not resolved on time, it is a potential source of future dispute. Another one is human behavior related. You remember the zero-sum mindset? If you have that kind of mindset, it's not too good for the industry. The positive sum mindset is better because you accommodate, and of course, you give necessary, compromise when necessary. But if the situation is adversarial, it becomes too controversial. That culture is bad. It's a potential dispute source. Lack of communication, for example, you are not communicating with the parties involved in the construction contract, is another problem. Because the more you understand the other party, the better the relationship between you. But if you don't understand yourselves, then it is a potential dispute source, because you wouldn't know what goes on in the mind of the other party. And that, of course, leads to the problem of team spirit. Lack of team spirit is another major human behavioral problem, which also, is a source of dispute in construction project. So we now have, apart from that one, we have the project-related source. Your project itself potentially could be a source of dispute. For example, you have the site conditions and unforeseen changes. Now, the site condition, for example, the architects during tendering, they would have informed you that there is need for tenderers to visit the site. But by the time you visit the site, you will know exactly what kind of equipment you should bring into that site, what kind of constraints you are having on the site. So that would inform the way you are going to price the tender. A tenderer that didn't visit site before pricing is actually, building up an unknown situation, which could be a potential source of dispute. Unforeseen changes, usually in substructure, you have not really, dig to know to what extent the foundation could be established, what kind of soil will be encountered during excavation, what kind of subsoil do you have? Could it be a filled up site that by the time you start your excavation, you may need to remove a particular item beyond the level you are supposed to get to? And that could change so many things. And if the consultant were unable to manage that properly, it could eventually lead to disputes. And that is why, when we look at site conditions as related to project issues, it means as a quantity surveyor, when you price, you put your substructure as provisional because you foresee that there are things that are unknown, unforeseen issues when it comes to underground matters. The next one is external factors that are neither related to any of the parties in the contract, nor even the project. And sometimes we talk of an act of God. So example of those external factors would be your weather, which could change anytime without any pre-knowledge. Legal and economic factors, like the NSAS issues that happened recently in Nigeria, those that were affected, whose business are along that corridor where it occurred, they wouldn't have expected such things to happen. So those are external factors, things that you never expected, that you didn't see as something that you may eventually encounter on that particular project. The same thing is this issue of COVID-19 on so many construction projects is an important factor that will lead to claims from the contractor, and the client is arguing he's unable to pay. So if there is no proper management of the relationship between them, it could lead to disputes. So fragmented structure of the sector, looking at the construction industry as it were, generally, any government policy could mean something else. And of course, you have different professionals involved. Those ones that you may not foresee while you are building up your project information, it could also affect the project, and that could be a potential dispute source. It is just like the way we are seeing things today, like the Nigeria market, the forex, the fuel price. Like recently, the government had to deregulate. Yet, you ask yourself whether truly we are prepared for such deregulation, whereby once there is increase in the fuel price, the increase that's supposed to be a blessing to Nigeria, somebody now see that then the fuel pump price is increasing. Is another economic challenge. That one you may not really be attached to the project itself. It is external to the project, but it could be a source of dispute in the long run if not properly managed. So in resolving your dispute sources, there is need for you as an expert, as a professional, to ensure that you take consideration on certain things. When you have a construction contract that you are managing, check the contract documents and ensure that you put consideration in the following. One, the exact description of the contract. For example, you are using a standard printed form of contract, either JCT, FIDIC, NEC, mention whichever one. The one that is common in Nigeria is the JCT anyway. Some, of course, FIDIC too is becoming popular too. So which edition is being used? Do you have sectional completion in the terms of the agreement there? Do any supplements or amendments apply? So these are some of the things that you need to know. In the case where you are having amendments contract, you need to take that amendment into consideration because it has a bearing to the relationship between the parties. The next thing that you need to look at the exact details for the appendices, completion dates, insurances. You see, on any construction contract, which is one of the things that you need to take note in your contract documentation, the appendices, where you have key area of clauses that will require peculiar information that relates to that particular project. So in that, you need to look at those appendices, those required information in the appendices, and be sure that the required information are properly filled. Sometimes people don't fill the appendices, but you must ensure that the appendices are filled and properly too, so that in it, you can have your completion date, the insurance, the LED amount that is allowed, the, what is it called? Retention amount, the percentage of it, the requirement for, what is it called? After the completion of the project, what you need to do during the defect liability period. Though some of these things, they are specifically mentioned, requiring the contractor to fill in his information there. So you need to study the appendix and ensure that it is properly filled. The text of any proposed written amendments, for example, the peculiarity of the contract will require that the client requires a particular amendment to the printed standard form. So you need to look at that and be sure that you are ready to abide by the requirements of the client. So the full text of any ancillary documents, such as bonds, guarantees, collateral warranties, and all that. On many construction contracts today, by the time you are starting the contract, the client might require that you should provide bonds for certain needs. For example, the advance payment bond, performance bond, and the likes. So you need to check for some of these things in your documentations before you even go ahead to say that, oh, we can execute and carry out this contract properly. So the contractor needs to have the opportunity to consider the documents when calculating a price and developing design solution. So this document will need to be included at tender stage. These are the things that contractors must ensure that it is properly assessed, appraised, and as consultant quantity surveyor, you prepare such documents and you must assess for each of the tenderers that are submitting for any particular project. So the next stage is to ensure that you take care of the following. Now you have the contract. Ensure that the contract is well prepared and signed as soon as practically possible. If the contract is not signed, it is a potential source of dispute. So once the client has had to appoint the contractor as the quantity surveyor on the project, ensure that the contracts were signed. Any proposed written amendments are expressly incorporated. Once there is any amendment to the form of contract, ensure that it is incorporated to the standard form that is being used to manage the project. Then full and complete descriptions of the words is also very important that you include that. avoid making general statements, because in general statements, specifics are not looked upon. And as you have been taught, specifics in terms of specification are very important in your description. So you need to set out a complete list of specifications, drawings, questions, and answers that apply to the appendices are completed fully and carefully. Also, the exact descriptions of the ancillary documents is referred to and copies are attached. Always ensure that the contract is signed. When you are distributing the contract, ensure that you have a full copy of that contract kept somewhere, so that you don't have the problem of loss in the transit or something while being circulated. Okay? So these are the issues that we have to discuss this morning. And I want to believe that it is well understood, and you will be ready to answer questions in case you are asked any. Is that understood, students?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Okay. So
Sir.
that takes us to the end of today's lecture. So I can entertain questions now.
Excuse me, sir.
Yes.